My name is Nicole Tamargo. I am the editor-in-chief of Moot Court, and I would like to introduce you all to Dean Elena Langen. Round of applause.
Thanks, Nicole. Thank you all for being here, not like you had a choice, because I think you're required to be here. But this really is one of our signature events. You really are going to have an opportunity to watch two fantastic oralists here. And you will have an opportunity to do this yourself next year. Touro really is known for producing practicing lawyers. And practicing lawyers will get up and argue before the judges. And that's what you're going to see an example of today. And I hope all of you will be thrilled and will be excited about having the opportunity to do that. Another thing Touro is known for is for our alumni to be very engaged. And you'll hear from Nicole who our judges are today, and all three are alumni. And all three hold significant positions of leadership here in the community. And again, this is a real credit to the program here. It's a real credit to the students who graduate from Touro. So enjoy today. It's a wonderful opportunity, and you're going to see Angela and Asfar do an absolutely fantastic job. They've been well coached by Professor Quinn, Professor Berman, and others. Yeah, you can clap for Professor Quinn. And you'll have the opportunity to really see a wonderful oral argument today. I'm looking forward to having them duke it out. So here you go, Nicole.
Thank you, Dean Langen. It is also my pleasure to introduce to you Associate Dean Myra Berman. I want to give her a round of applause. We have our two finalists, Angela Paolino here today, and Asfar Mirza. With the aid of our hard-working advisors, our wonderful e-board, and an extraordinary Office of Administration, this event was made possible today. So we are honored to have the esteemed judges with us this evening. We have a bench of 3 Touro alums, Cornell Bouse, the past president of the Suffolk County Bar Association. We have Dorian Glover, the past president of the Nassau County Bar Association. And we have the Honorable Valerie Cartwright, Justice of the New York State Supreme Court and a former Bainbridge winner. As most of you have seen in the program, this is an issue regarding which constitutional standard should be used to assess the exercise of force against school personnel when disciplining students. You have the reasonableness Fourth Amendment standard or the more onerous shock the conscience standard under the 14th Amendment. And without further ado, I present to you the final round of the Bainbridge competition. Good luck to you both. Bailiff Mohan, you may proceed.
All rise. Oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated.
Good afternoon. We are here today for number 1 on our docket, the West Terrovania School District and Officer Wayne Zander versus Amara Flowers on behalf of JF. Petitioner, your appearance, please.
Angela Paolino, counsel for petitioner.
Respondent, your appearance, please.
Asfar Mirza on behalf of respondent.
You may proceed.
Thank you, Your Honor. Good afternoon, Madam Chief Justice and Your Honors, and may it please the Court. My name is Angela Paolino, and I represent petitioners, the West Touro School District, and Officer Wayne Zander. With the court's permission, I would like to reserve 1 minute for rebuttal.
Granted.
Would the court like a brief recitation of the facts?
We can dispense of the facts. The court is familiar with the facts in this case.
Thank you, Your Honor. Your Honors, the need for safety and security in our schools is paramount, especially in a society today where violence and disruption can undermine the educational experience. This school urges this court, as a matter of law, to adopt the 14th Amendment's due process test, which is a 4-pronged test laid out in the 2001 Gottlieb versus Laurel Highlands School District case that states, 1, was there a pedagogical justification? 2, was the force used to serve a legitimate objective? 3, was the force used in a good faith effort to maintain discipline? And 4, did a serious injury result? The test is an easily adoptable standard that includes language such as pedagogical that is specifically geared towards school settings. The 14th Amendment test is important because it balances the needs for schools to create policies that safeguard all students while also respecting their individual rights. As to my first point, this court in the 1985 New Jersey versus TLO case, they stated that the Fourth Amendment applied only in searches in school settings, not seizures by a school official in a school setting. This court in the 1989 Graham versus Connor case speaks broadly as to what a seizure is. However, they only applied that standard of force to police officers, not school officials in school settings.
Counsel, if you please, can you speak to me about the shocking the conscious? I'm a little concerned about that aspect with the test. What's your view of shocking the conscious with this test?
Your Honor, in the Third and Sixth Circuit, in the 2001 Gottlieb versus Laurel Highlands School District case, and the 2016 Domingo versus Kowalski case, the court explains that this term shock the conscience has always related specifically to criminal procedure situations, not to school settings, even though it emanates from the 14th Amendment's due process clause.
So you're saying it should not apply here?
Here, the petitioner is proposing.
Correct?
That specifically, no, Your Honor.
Okay.
However, the petitioner is proposing a different type of 14th Amendment here, which is enunciated in these two circuits, which is the 4 prongs that I stated earlier in the Gottlieb case.
Do you think that what occurred could shock the conscious?
No, Your Honor.
Well, let's just say for a second, where's my timekeeper? Can you count to 15, please? 15 seconds, because that's what happened to that young person with the taser. Please commence. Out loud.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15.
You know, walking in here on this carpet, if I were to touch something and get a shock, in that scintilla of time I'm removing my hand, it could have felt like a lifetime for that young person. How does that not apply?
Your Honor, we must use the 4 prongs of the Gottlieb test as it's specifically geared towards school settings. Here, Officer Zander was
But
a trained...
I want one answer from you here. Officer Zander, in that moment, do you believe in your heart that that would shock your conscience, that that tactic was used for 15 seconds?
Your Honor, this was a lawfully issued taser by the schools. And the bigger picture here is that we must not impose such a heightened liability on these schools. These schools need to protect their students and all students, and that is a pedagogical objective of Officer Zander today. As well, if we take the record step by step, this was an unruly and disruptive student. She was known for her past behavior. When she threw a desk across the room, assaulted another student, and then approached to attempt to flee the building.
What did she do here? She went to a safe space, but someone else was in that room.
Yes, Your Honor, and she was still agitated. So therefore, she ran towards the door, and she kicked on that door repeatedly. She is 5'8" and 185 pounds.
What are
She
you
is no-
saying there?
She is no
You're
small
saying
girl.
something. What are you saying there? 5'8" and that weight. What are you saying?
She is no small girl. She got away from Officer Zander. He tried to talk to her and calm her down. He told her he was going to tase her. He held her wrist, and she still managed to get away. Officer Zander, with his training, he was taught the drive stunning method. And in this situation, it was appropriate and did not shock the conscience. Therefore,
Thank you.
Counsel, isn't the shock the conscience test almost impossible to meet under Hall and Gottlieb?
Your Honor, if we look to that, we look to the reasonableness test that my adversary might state, that is also too easy to meet. It is too uncertain, and it will tie the hands of our school officials who are legitimately trying to detain an unruly student like here. If we look to the Third Circuit in the Gottlieb case, that court recognizes that schools are under unique constitutional protection because the state agents have a strict authority to protect students' movements while in a school. As well, the Third Circuit states that Fourth Amendment applies to intrusions on privacies, not necessary exigencies in the moment that might look like seizures. The 14th Amendment allows momentary force in reaction to an unruly student, something that the Fourth Amendment does not textually or historically apply. As well, in the 2016 Domingo versus Kowalski case, that court adopted the 14th Amendment's due process test and states that it still awards students constitutional protection, but only from egregious conduct which is arbitrary in the constitutional sense. That court applies the Gottlieb factors to the facts and holds that there was no constitutional violation. We must do that here. We must look to the four factors.
Ms. Paolino, is it your position that a would-be criminal or a suspect on the street has more constitutional rights or should be treated favorably versus a student, a young student in a school setting? It's a simple question.
Your Honor, if we look to the 1985 New Jersey versus TLO case, they applied the Fourth Amendment to school settings. However, they applied a lessened version of the Fourth Amendment when applying it to schools specifically, stating that the school officials need not obtain a warrant or a probable cause like a police officer.
Your position is that students should have less of constitutional rights than a criminal suspect in the street?
Yes, Your Honor. As well, to my point there, if they need not obtain a warrant or probable cause when conducting a search. They apply a two-pronged test there that states whether the search was justified at its inception and whether it was reasonably related in scope to that justification. Even if this court were to adopt the Fourth Amendment's reasonableness test, these acts by Officer Zander was reasonable in light of the exigent circumstances. As to the first prong,
Well, you don't concede you lose if we adopt the Fourth Amendment?
no, Your Honor, we would not lose under any tests, and therefore there is no constitutional violation.
Counsel, what about the child's lack of resistance?
Your Honor, as I stated earlier, Officer Zander is a trained official.
2 years.
He was trained,
2 years.
yes, Your Honor.
Child with mental health issues.
Yes, Your Honor. If we look to our mental health issues, we wouldn't know if she went on the streets and perhaps got hit by a car or anything else caused harm to other people. She needs to be under a strict supervision. These students especially need to be under a strict supervision. And if we look to the 2016 Domingo versus Kowalski case, those students were also special education students. And there, they were not awarded constitutional protection because there was no malice, there was a pedagogical purpose, and no serious injury resulted. Here, there was no serious injury that resulted. As to the record, urinating, defecating, and vomiting are not serious injuries, and there was no signs of psychological trauma.
Counsel, isn't it true that Officer Zander had dealt with the child on prior occasions and that he had no direct evidence of what the child did on this occasion before he decided to deal with her in such an intense manner? Wouldn't that in and of itself be malice by officer?
No, Your Honor. If we take the record step by step, what occurred at the door is most important here. When she approached the
Whoa.
door,
What about the taser?
Your Honor, the taser was used to make sure that she did not run out and further harm herself.
So you want this court to just focus on the door, not the action of Xander with the taser?
No, Your Honor, it's a bigger picture than that. Here, we must focus on not imposing such a heightened liability on these schools. These schools need law and order. As schools today, they're so violent. And
Please continue to answer Judge Cartwright. Thank you.
Thank you, Your Honor. There is no malice here, because when that student approached the door, he tried to talk her out of it. He tried to calm her down. He said that he was going to tase her before he did it. When he put his hands on her wrists, he didn't touch her no further, but she got away. And this was appropriate in these circumstances. And if we look to the Fourth Circuit and the 1980 Hall versus Tawney case, they explain their rationale behind the due process test in school settings. They state that substantive due process is concerned with violations of personal rights of privacy and bodily security that rise to a higher level than magnitude. And the court emphasized that when courts hear a state tort claim, their decision may well turn on whether their particular amount of force was excessive. That does not mean that there was any constitutional violation under the 14th Amendment's due process test.
I'd like to bring you back to the first two Supreme Court cases that you cited, decisions by my colleagues. How do you reconcile the standard that you're proposing with those two cases? In one of those cases in particular, it says search and seizure.
Your Honor, the petitioner here is not here to question those decisions. However, in the 1989 Graham versus Connor case, this court only applied the totality of the circumstance test to police officers, not school officials. And even in the 1985 New Jersey versus TLO case, they applied it to searches in school settings, not seizures by school officials. So here, as the overall objective of our case is to protect these schools, the language of the four factors of the Gottlieb test should be best implemented in these situations, especially in a situation where there are behaviorally challenged students like the respondent herself who needs these extra protections in school settings. As to the pedagogical justification, we must adopt a broader version of it here, because it's not just learning in classrooms, it's a bigger picture. We need to provide safety for all students, not just one individual student. And here, Officer Xander's acts were constitutional under either amendment. Your Honors, for the foregoing reasons, the petitioner is requesting that this court reverse the 18th Circuit's decision and further adopt the 14th Amendment's due process test. Thank you, Your Honors.
Thank you. Respondent, you may proceed when you are ready.
Good afternoon, Your Honors.
Good afternoon.
May it please the court. My name is Asfar Mirza, and I represent the respondents, Amara Flowers, on behalf of JF in this matter. Today, this court weighs the effects of using a standard that balances the needs of students and school officials in the totality of the circumstances versus an almost impossible to meet standard that tips the scales in favor of the school officials. The respondent, a vulnerable 15-year-old girl with intellectual disabilities, was tased by Officer Xander after an emotional outburst. Although she had ceased struggling and laid face down, he continued to tase her.
Counsel, we're aware, but your opposing counsel has indicated that the young person was attempting to leave. Speak to that, please.
Yes, Your Honor. This student was attempting to leave the premises after she had attempted to go to a chill-out room, a room that this school had designated for her to allow her to fulfill her emotional capabilities, where she could register her emotions in this room so she may not struggle outdoors. However, when she was leaving, this officer tased her for a continuity of 15 seconds. The degree and the length of this taser.
Right, I'm aware, and we're all aware, but your opposing counsel made a very good point. See, I went to the esteemed Jacob D. Fuchsberg Law Center. There was a professor that I had in contracts, and when someone gave the correct answer, the professor would say, precise de mundo. And I would have said precise de mundo to the response that was given to me when I'm making the point you're making. I would like you to speak to one aspect of what counsel indicated, that the school needs to provide safety for all. What say you?
I understand, Your Honor. The school must provide safety. However, in this situation, what petitioner contends is not safety, but instead that we fight fire with fire. The petitioner contends that students and schools all around the United States have an increase of violence, an increase of drug use. And the petitioner contends that we must establish tasers in schools, and we must establish...
This taser was applied by the school.
Yes, Your Honor.
Was handed to this Mr. Zander.
Yes, Your Honor. However, in this situation here, the taser was not used appropriately. What we see here today is that taser was used beyond the means that this school had given to the security officer. What we see...
Let's go to the standard. So your argument is that the reasonable standard should be utilized. Doesn't that tie the hands of the officials in providing the safety for the children?
Respectfully, Your Honor, no, it does not. Here in this situation, we follow what this court has already established, that the Fourth Amendment does in fact govern in schools. Yes, this court has established that it governs for for searches, but here, in this situation, we must find that it applies to seizures as well.
But you're asking us to take one step forward. So you're conceding that the two Supreme Court cases that were referenced by opposing counsel do not address seizures. Is that your position?
Your Honor, it may not explicitly define seizures. However, what they do is, upon that, is implicitly decide on it. If we look at the 1989 decision...
I'm sorry, I missed the last part of that sentence. Can you please answer Judge Cartwright's question again, please?
Yes, Your Honor. This court has implicitly been deciding to extend the Fourth Amendment towards schools for unreasonable searches and seizures. So today, this court must explicitly decide this and affirm the decision of the Circuit Court that the Fourth Amendment does in fact apply to unreasonable searches and seizures within the school environment.
So this is a new issue because we have never explicitly held that it applies to seizures. Is that your position? And you're asking the court to take one step further and now apply it to seizures?
Yes, Your Honor. This one step forward, however, is not a far step, as we have seen in other cases by this court, especially in the 1985 New Jersey versus TLO case. The decision of this court was that the Fourth Amendment governs searches in school environments. The reason that this court has applied this decision is because of the role of the school officials. School officials are government officials by their roles. This court's reasoning was that this role is synonymous. This role exactly is to further publicly mandated educational and disciplinary standards. The court furthers this and emphasizes this by looking towards the purpose of the Fourth Amendment. The purpose of this amendment is to protect the privacy and security interests of individuals against arbitrary invasions by government officials. We find here in this court case that Officer Zander, the security officer, was in fact a government official under the Fourth Amendment standard.
Who was trying to protect the safety of the young child as well as the safety of the children. That isn't it a good thing that the child was stopped from leaving the actual school premises?
Your Honor.
That's a yes or no, isn't it?
Yes, Your Honor.
Okay, well, what's the answer?
We contend that...
I still haven't heard yes or no. That's a yes or no, isn't it?
No, Your Honor. What we see
It's
here...
not a good thing.
It is not a good thing in this matter.
Okay.
What we see here today is that the petitioner is contending for us to look at the bigger picture, to look at the fact that we must protect students, we must protect the school officials. However, what we see here today in the matter before us is a school official has
wouldn't you be
tased.
suing the school if, in fact, the officer was unable to stop her from leaving the premises?
Your Honor, that may be the case. However, what we are looking at today is a claim of excessive force by a school official that tased for 15 seconds a young student who may have psychological trauma and has come from a war-torn country and has been established in this school, where this school is meant to take care of her, to comfort her. However, she is met with pain and she is met with violence. The reasonableness standard that we ask this court to adopt is not the one that the petitioner contends. The petitioner contends that we must look towards the New Jersey versus TLO standard, which is whether the action was justified at its inception. However, this reasonableness standard was only applied to searches. The standard that must govern for seizures is the standard that this court has already applied. In the Graham versus Connor decision, we applied the totality of the circumstances reasonableness standard, which is whether the totality of the circumstances justifies a particular sort of seizure. And this is without regard to their underlying intent or motivation. This is the standard that must govern for seizures, not the other reasonableness standard that petitioner contends. This test will show... Yes, Your Honor.
Based on your statements to the court, it's clear that you believe that it was an unfortunate circumstance that the child was tased. However, isn't it equally true that she did not suffer any serious injuries from the actual tasing? And isn't that a factor that this court must consider?
Your Honor, unfortunately, this student has received a serious injury. This court must find that the serious injury here was not the serious injury of a physical force. It is psychological trauma that we see here today.
So we're weighing the psychological trauma against the need for safety for her attempting to depart.
Yes, Your Honor. However, in this case, the attempt that she has made has been convoluted by the petitioner. The petitioner has contended that more harm may have come.
Well, do we know?
Your Honor, we do not. This is speculative in nature. But what we do have in front of us is the pure hard facts, which is that this student, this 15-year-old girl, was tased beyond what was reasonable. She was tased for 15 seconds.
Tased for 5 seconds, would you be making a different argument?
Yes, Your Honor. If that excessive force is beyond what is reasonable in the totality of the circumstances, we would still be making the same argument.
What is reasonable in this case?
Your Honor, what is reasonable in this case is when we look at the circumstances.
No. Stay on the taser. What's reasonable? 1 second? 2 seconds?
Your Honor, in the totality of the circumstances, the use of a taser is unreasonable. This is a student here.
You just said that the use of the taser, the way I heard it, was reasonable. Your problem was with the length of the tasing, if you will. Am I correct?
I'm sorry, Your Honor. No, respectfully, what we have here today is, yes, as per the totality of the circumstances, the degree and the length of the tasering is unreasonable. However, the use of the taser itself is unreasonable as well. We look towards the degree and the length because of the fact that it illustrates the unreasonableness of this
I
conduct.
think you just indicated that if it was 5 seconds, you would have been okay with it, or am I incorrect?
I'm sorry, Your Honor. If it was 5 seconds, this would still be unreasonable. The use of this taser is unreasonable in general.
So 1 second would have been unreasonable, under your argument.
Yes, Your Honor.
Okay.
Your Honor, if
The school, because they've issued tasers to the school officers?
Your Honor,
Trying to ban that altogether?
no, Your Honor. Today, we are here to specifically look towards the excessive force that was used against the student. What may come later by use of this excessive force is unaware to us. However, what we have in front of us today is the fact that this is excessive in nature. It is unreasonable in nature. And Justice Glover, as you asked, or as you pointed towards, the unreasonability of this. This conduct must be found to be unreasonable because we must look at the totality of the circumstances. Given the age of this student, 15 years old, given the disability of this student, her emotional outbursts that this school is known to help with, this school is created for the purpose of helping these disabled students. Given all this information, and then when we look towards the school official, the security officer, whose training is to de-escalate violent situations, whose training is as a retired special education teacher.
Give us the answer, if you please. What would be the requisite response in this situation in light of what you just described? Her challenges mentally, the behavior in the moment, the approach of the door. What was supposed to happen?
Your Honor, much less than what occurred. What we saw...
We can really take that to the bank. What else?
If I am understanding correctly, are you asking me what would have been reasonable?
Oh, well, yeah, precisely.
Your Honor, what would have been reasonable is if the officer had never used a taser.
So your objection is taser only then?
My objection is the tasering, and we see this illustrated, the unreasonableness of this, due to the length and degree of the tasering.
Thank you.
Your Honors, the petitioner has contended a four-pronged test. The original language of this test, which has been strategically framed to influence judicial perception, is that looks towards the malice and the intent of the officer.
Yeah, let's do that. Do you agree that Officer Zander did not intend, right? Like I learned at Touro, the desire or purpose to bring about something. Do you agree that he didn't intend to harm the student?
Your Honor, we disagree completely.
How do you know his mens rea?
We may,
You know the actus reus.
Your Honor, we may infer the malice and the intent of this
So
officer.
you want this court to infer his mens rea?
Your Honor, we would like this court to look at the totality of the circumstances and see that this officer had no awareness of the desk being thrown. This officer's only awareness was his prior interactions with this student. And these prior interactions were the student punching lockers and cursing out teachers. This is nowhere close to the actions that we see here today. This is not reasonable compared to the knowledge that he had. The objective reasonableness standard test asks us to look at the totality of the circumstances.
Don't you think that Officer Zander has a right, in the position that the officer's in, to look at the past conduct to see what measure may be appropriate under the circumstances?
Yes, Your Honor. And if this
Well,
security
how does your
officer-
argument circumvent that?
Your Honor, the knowledge that this officer has, the interactions that he's had with this student, have been limited to the student cursing out teachers and punching lockers. It is nowhere close to the actual conduct that occurred. This security officer is unaware of the fact that a desk was even thrown. This security officer is basing it solely on his prior interactions, which do not show that he had any reasonable requirement to tase this poor girl. Your Honor, the test that petitioner contends is an almost impossible to meet standard, a standard that requires the student to prove that this security officer had malice, that he had the intent to harm. As I said, we have seen here today that this exists. We see.
Well, we asked your opposing counsel about the inability to meet that standard, and she indicated that the reasonableness standard is way too lenient. So how do you address that?
Your Honor, the standard, the reasonableness standard, is not too lenient to meet. It is not an easy standard to meet, as all it requires is that we must look at the totality of the circumstances. If we look at the circuits that have applied this standard, which is the 7th and 9th Circuit, they have found that when this standard is applied,
But aren't
specifically,
you asking us to use now a reasonable standard, what a reasonable, prudent person would do in a particular moment who had the history of a young person with violent outbreaks and assaulting others? You're asking us to bring that, but not the test.
Your Honor, we are asking for us to bring the test, the reasonableness standard test that this court has themselves used in the Graham versus Connor decision. This test is the correct test to use, as this test will allow a balancing of the needs of both the student and the school officials. Your Honors, my time is up. May I briefly conclude?
You may.
Thank you, Your Honors. Your Honors, conduct such as this that we see here exhibited by the security officers cannot be allowed to exist. We see that the school officials have been given too much leeway. The balancing of the needs is disproportionate. This court must affirm the decision of the circuit court to allow the needs of the students and the school officials to be balanced. And this can only be done through the reasonableness standard. Thank you, Your Honors.
Thank you. Petitioner, are you looking to rebut, or are you waiving your rebuttal time?
Yes, Your Honor. I would like to rebut.
You may proceed.
Your Honors, petitioner would like to make 3 points. 1,
First point I'd like to make is opposing counsel has asked us to bring the reasonable, prudent person test in light of Officer Zander's experience. Why would we not do that?
Your Honor, the respondent contends that we must adopt the totality of the circumstance test. However, Officer Zander is not a police officer, and in the 1989 Graham versus Connor case, they only apply that test to police officers. Therefore, the reasonableness test would not be appropriate. And that was to my first point of my rebuttal.
Thank you.
As to my second point, There was no psychological trauma, as the respondent contends, because the record does not point to that. And to my third point, Your Honors, the taser that was lawfully issued to Officer Zander is a non-fatal tool to temporarily detain an unruly student like the respondent herself. Therefore, the 14th Amendment is the only appropriate standard.
Can you tell us what would shock the conscience?
Your Honor, what would shock the conscience would be that he perhaps tased her longer, didn't bring her to the nurse after. He brought her to the nurse after. There was no ill intent here, and perhaps that would shock the conscience, Your Honors. Thank you.
Wait, don't go. How much longer of tasing?
Your Honors, perhaps for a minute. However, it would be hard to say here, but Officer Zander did bring her to the nurse after, and he did attempt multiple times to not let her through that door, but she kicked and she kicked and she kicked and she got through.
Thank you.
Thank you, Your Honors.
Thank you. Thank you. This court is in recess. We will be back momentarily. Thank you. You may be seated.
All of our judges will now deliver feedback.
Thank you. As Chief Justice, I am given the privilege of speaking first on behalf of the entire bench. After hearing the arguments presented by each of you today, there is consensus amongst my colleagues that each of you have done an excellent job. You both were extremely impressive and persuasive and had a knowledge of the facts and the law. You were very poised and you were professional. But we must remember that this is an oral advocacy competition. And it is the competitive aspect that embodies the nature of being a litigator, whether it's on trial level or on an appellate level. There's always one side that must come on top. Sometimes it's by a mere margin, and sometimes it's by a landslide. But I think I can speak for my colleagues that it is the former in this case. You are both very good on your feet. But today's winner, the student that has been selected as the 2024 Bainbridge winner, is Asfar Mirza. I'd like to say congratulations to you both because both of you are winners. The experience that you have learned here hopefully will shape your not only training here at Touro, but your legal careers. And I can say that from my own experience, having stood there at the 19th annual Bainbridge competition. So I want to turn it over to my colleagues so that they can give you some feedback to each of you individually before we allow you to have some time with us after this presentation today.
Judge Cartwright, thank you. And I want to congratulate both of you. You know, I'm class of 1989, a long time ago. I think it's a different building, though. I'm not sure. But I am so proud to be here. And every time I judge this Bainbridge competition, I remind myself, and I like to remind both of you, the idea that you're both here in this capacity, you win. And I've judged so many moot court competition, many Bainbridge, but many moot court competition, and it's always very difficult. And as we walked in the back, I think one of us said, this is going to be tough, because we have to pick. We can't make it a draw. And I'm thankful that we're supplied with a checklist, and it was very thoughtfully put together, so it gets us thinking. And there were some areas where Mr. Mirza was slightly better, and some areas where Ms. Paolino was slightly better. But it boils down to numbers, and once the numbers are done, we have to accept them, and we did deliberate. We spoke between ourselves. We reminded each other of what just took place, the positives, and what might even be a slight negative. And it is difficult, but slightly more, Mr. Mirza, and congratulations. But I've handled countless trials before juries, and I know how difficult it is to stand on your feet and collect your thoughts, especially when judges are hitting you with questions, which doesn't happen in a jury trial. In a jury trial, you're hitting the witness with questions, and then you're arguing in front of a jury, and jurors don't talk back to you with questions. Although that has happened, but it's extremely rare. But the idea that both of you stood on your feet and took our questions, and we were very rude, as we're supposed to be, and interrupting you.
Wait.
He's like, you're not talking about me.
But, we do. We interrupt you. No, I'm cutting off your thought. Here's my question. Both of you stopped, heard the question, and answered it the best you could. And again, I congratulate both of you for that. And again, it's my privilege to be here. I think the enthusiasm in both of you, I know the preparation that you put, and I know there are people here watching. You knew there were going to be people here watching, but that makes a good attorney. A great attorney, not only a great attorney, a great trial attorney has to think on his or her feet and have the eyes on them at all times. That's the tough job, and you're both phenomenal, out of the park. Dorian?
Thank you, Judge. I would join and I adopt the comments that were previously stated. I think you're also preparing for me, since I've been here so many times, because each one of you know that I talk about pivoting, and that's the ability to move from one topic to the next when there is that interruption, and both of you, hands down, accomplished that. I could not, and did try, to throw each of you off of what you've written, which is what practice is like. You come in with something, a particular state of mind, and it changes, which means being on this side after you complete here, life is like that. You may have a plan, but it's what happens inside the courtroom as you walk through the door. And both of you walked through the door today and were extremely prepared and made it extremely difficult for us with a margin that you would not believe, because I was shocked. I prefer judging when it's like this, and that was not the case. Both of you are outstanding. Both should have your heads held high, and I thank you for the opportunity to be here and witnessing that.
Thank you. And with my final comments, first, I echo the sentiments of my colleagues. I just want you to remember that when you are put under pressure by the judges, in whatever courtroom you're in, just be very careful as to your responses. At times, you just want to get to the next thing, and something you say may be such a substantive error, which wasn't in this case, but it could be such a substantive error that it could be to the detriment of your client. So just be very careful as to how you shift to the next topic. You were very good at coming back to what's in front of you. So just be careful that when you do get a little nervous, you learn how to keep your composure. And that's something that law school training is going to teach you how to respond to pressure, what it is that puts you in the best position to be able to deal with the pressure of walking into a deposition, walking into a trial before a judge, or even walking into your professor's office or your boss's office for a difficult conversation. These are pressures that come undoubtedly with being a lawyer. And you need to, hopefully you're learning now through law school how to deal with those pressures. You both did a really good job. You did not bow down to the pressure. You stood up, and even when we can tell you were a little flustered, you responded to the best to the best ability that you had, and you kept moving to the next thing. So please just think about that. And for everyone that's here that's listening and watching, this is difficult. This is extremely difficult, and one of the most difficult things about being in moot court also is the training of being able to, as my colleague said, pivot from being petitioner to respondent, then from respondent to petitioner within 5 minutes. What that does, though, is it trains your brain to be able to understand an argument so well that you anticipate what the other side is going to ask and you're prepared for it in advance. So think about what you've seen here, and even if you choose not to be part of moot court, think about what they're learning and how their brains are being trained, and figure out how you're going to train your brain to do the same thing, because it is important, especially if you want to be a litigator, whether it's on the trial level or an appellate level. But I want you to give them a round of applause for their performances here today. And if I was at a law firm, I'd hire either of you. I believe that we are at a point where we are adjourning. Is that correct? Yes. We will, are we allowed to stay for a few minutes in the event anyone would like to speak to us?
Of course.
Okay, so we are concluding today's proceeding. Court is adjourned, and we will be here if you'd like to ask any personal questions of the judges. Thank you.